I don't think there is, in the sense that I don't think this is an order that can be appealed to the New York courts at this stage. I suppose they could try to run to federal court to seek a stay. I don't think that that is likely to succeed. He's previously tried to remove the case to federal court, and that was rejected. I think that as a practical matter, the thing that might delay it would be if there's movement in one of the other cases. For example, if the U.S. Supreme Court were to say it wasn't going to take cert on the case involving immunity in the January 6th case, or if it quickly decided against him on that case and that matter were reset for trial in D.C., that wouldn't preempt this trial in terms of the trial date. But if it looked like that were on track, one could imagine that the two judges, the D.C. District Court judge and the judge in New York, would communicate, and the judge in New York might defer to the preparations for that case, which is what we all thought was happening initially before the case got put on hold in D.C. So it could be a calendaring issue between various courts, but legally, I'm not seeing the route to delay the proceedings in any other respect.
Jessica, it's good to have you back on Bloomberg TV and radio. I'm wondering if you can talk to us, assuming this trial starts as planned March 25th, what jury selection would look like. Bloomberg is reporting that jurors may have to disclose what bumper stickers they have on their cars, whether they've read The Art of the Deal, what radio shows they listen to. How difficult will it be to assemble this group in New York?
I think it's going to be a challenge to select a jury that can be fair and impartial in this case. I think the voir dire process, that questioning of jurors to know what they've heard about this case and whether they think they can be fair and impartial, is going to be a challenging one. That said, the judge who presided over the civil case, the defamation case, and the sexual assault case involving E. Jean Carroll did impanel a jury twice. So we know it has been done before in New York and these two courthouses, the federal district court where those defamation cases were tried, and the criminal court where this case is going to be tried in March. They're just across the street from each other. So they're drawing upon many of the same jurors, not exactly the same jury pool. The jury pool for the Manhattan case is Manhattan, as opposed to the federal district court, where it's a broader district. But nevertheless, it's been done. I'll be very interested to see what, if any, protections are put in place for those jurors. As you may recall, in the civil defamation cases involving E. Jean Carroll, the judge made those jurors anonymous, meaning nobody learned their identities. And so I'll be very interested to see what, if any, discussion there is about protections for the jury in the criminal case against former President Trump.
Well, yeah, the security considerations around this certainly are significant, considering this is a former president we're talking about. And I would imagine there will be quite a circus in New York as this trial begins. I feel like it's worth reminding our TV and radio audiences, Jessica, just what exactly it is the former president has been charged with here. We're talking 34 counts of falsifying business records, usually in the state of New York. That's just a misdemeanor. And Alvin Bragg made them felonies because he says it was done with the intention of violating state and federal election law. Can you just walk us through the strength of these cases, bringing these charges, making them felony charges specifically, and how likely it is you think he would be convicted on all or any of them?
So the charges that were brought, as you mentioned, are falsification of business records. Under New York law, that can be a misdemeanor at its most basic level when a person intentionally creates and enters into the business records of their organization false entries. But it can also be a felony when that false entry is made with the intent to further or conceal another crime. And as a felony, that is frequently charged in New York. So it's not all that unusual that this crime in its felony version is charged. Here, the allegation is that the false entries were made in the business records of the Trump organization in order to conceal the payments to Michael Cohen to reimburse him for the payments he in turn made to Stormy Daniels and to others to conceal an alleged affair with the former president at the time that he was running for office in 2016, when it was thought that if the affair became public, or the allegations of the affair became public, that would hurt his campaign chances. And the reimbursements to Cohen for those payments that were made during the campaign continued in 2017, even after Trump took office. Now, the legal theory for the crime that Trump allegedly was trying to further or conceal through the false business entries, which was those entries of the payments to Cohen as reimbursement for or payments for legal fees. Sort of those underlying crimes that the entries were designed to conceal are alleged to be several, including violations of the federal elections law, violations of New York State elections law, and violations of New York State tax laws. And the court basically said those are three permissible theories to underlie the charge, the felony charge, that the false business entries were designed to conceal one or more of those crimes.
This will smack of a tabloid trial, though. We're going to have Stormy Daniels on the stand here telling the story, Michael Cohen telling his story all over again?
I would say certainly we will have the testimony of Michael Cohen. I imagine we would have the testimony of Stormy Daniels, although to my mind that's less clearly necessary. But yes, Michael Cohen would be an important witness for the prosecution. We all are familiar with the problems of his credibility, given that, among other things, he has pleaded guilty to lying under oath before. And all of that will be explored, I'm sure, on cross-examination. And I imagine that the prosecutors will actually elicit it on their direct examination as well, so that they are putting before the jury everything that they know about Michael Cohen, and the jury can evaluate his credibility. And the key to the case from the prosecution's perspective is going to be, can they corroborate Michael Cohen's account with the testimony of other witnesses and with documentary evidence, including the checks that were made out to him, the invoices, and other documents that would corroborate his account about what those payments were for.
Jessica, we only have about a minute left with you, but I also want to get your take on the response we got from the special counsel here in Washington, Jack Smith's, to the Supreme Court after Trump asked for a stay in this case here. Jack Smith basically says the case should go forward without delay because the nation has a compelling interest in seeing the charges brought to trial. How do you expect that the court will decide here, and how soon?
It's really hard to say. I imagine that the court will decide fairly soon, perhaps as soon as next week, whether it's going to grant the stay or not. That's the first thing it has to decide. Will it stay the mandate from the District of Columbia Court of Appeals? If it doesn't grant the stay, then the case is going to go back to the district court to resume the trial date, which is what we started talking about earlier. It also will have to decide whether to actually review the case independently of the stay. So there's a scenario where they don't grant the stay, but they do say we'll consider the case on the merits. It's hard to say whether they're going to take it or not. It is such an important novel question, whether there is immunity from criminal prosecution for a former president. But it's really hard to predict.